Well, the Supreme Court hearing oral arguments on President Biden's student debt plan to cancel $400 billion in student debt this week, and millions of borrowers are paying close attention. But how long could something like this take? Let's bring in our panel to discuss. Civil litigator and constitutional lawyer Bruce DeValle, and joining us also is distinguished professor at Touro University, Thane Rosenbaum. Bruce and Thane, great to have you here. Bruce, I want to kick it off with you. We talk about this all the time, especially when I do my phone a friend about break down the Supreme Court case for us. What's the central question here in this student loan case? Is it the fact that does the president have the authority to forgive student loan debt?
Yeah, Kilmeny, that's a great question, because I think lost in the middle of all of this sturm and drang and noise is the essential issue. And the essential issue is a constitutional law issue. The question is, does the president have the authority to undertake what Congress has the constitutional authority to do, which is to create laws? The fundamental question here is, did President Biden overstep his boundaries? And I think he did. The court is probably going to decide this on a couple of things, or standing issues, which are problematic for the plaintiffs. But the major question doctrine is the fundamental issue here, from the West Virginia versus EPA case and other cases. And what those cases say is, if it's a fundamental but major question, Congress has to decide it. The agencies don't have the power to just run roughshod over everyone in the United States. And it's a pulling back of the agency state in the Chevron doctrine.
Thane, from what we heard during oral arguments, what are the justices weighing here?
So it's interesting. On some levels, I think this is a separation of powers case. And the conservative justices in particular seem to be making this checks and balances. Did the president overreach? And because remember, Congress has power of the purse. The Constitution is clear. Congress deals with spending, taxation, appropriations. So they're in the money business, right? And so the question is, when you're talking about $500 billion, how can this be done without congressional authority? But there was another thing that came up with the conservative justices, which you could describe as the fairness question, which is, why is it in this instance that we are favoring student loan borrowers over, say, other people who were also very much damaged or prejudiced by the economic consequences of the pandemic? So we saw some of the conservative justices weigh in there as well. But I do think it's true that this court has already demonstrated last term that it's willing to override the EPA, the CDC, the OSHA in dealings with climate change and vaccine mandates for large corporations, moratoriums on rental evictions, when they think the executive branch has exceeded the authority that it's been given. And that might be what the conservative justices rule here.
Yeah. Bruce, what do you believe to be at stake here with regard to the court's decision?
I think what's fundamentally at stake is whether or not the pulling back of the agency monolith is going to keep happening. And I think, if questioned, many people in America would not have a problem with that. I think the faceless agency and the governmental oppression through faceless agencies is more than a trope, more than a work of fiction, an Orwellian. It's a reality. And what I find absolutely fascinating and somewhat wryly comical is we now have the liberal justices jumping all over the conservative justices for being concerned with fairness. Justice Sotomayor went so far as to say in her questioning, well, it looks like what the court wants to do, the conservative justices, they're looking at Congress and what Congress said, and if they don't like it, they're not going to do it. Well, that sums up liberal jurisprudence for the last 60 years. It's an oddity where we have the three liberal justices are probably going to become strict constructionists. And look at the language.
Thane,
so it's peculiar.
Thane, how do you see this playing out?
Well, I want to add something that Paul said that I thought was important, which is that, remember, the founding fathers really cared about representative democracy. So their position was, if you're going to make decisions, it should come from legislators, because that way individual people, citizens, are voting for their local legislator. And so when Paul used the word agencies, what I think the audience should think about is, we're dealing with, over the last few years, the EPA, the CDC, OSHA, in this case, the Department of Education. The question there is, they're not elected, right? Individuals did not elect people to the EPA, Environmental Protection Agency, or the CDC. So that's another reason why it's important to think about how these conservative justices, who are in some ways, strict constructionists of the Constitution, might in the end say, this is the major doctrine question. These people are unelected, unaccountable. They're making huge decisions without congressional authorization.
All right, gentlemen, great points. Appreciate you both being here. Thane Rosenbaum and Bruce DeValle.
Anytime for you, Kilmany.
Yes, absolutely.
Thank you.